we did have two of those 7 jurors who said that they had heard this news, but they weren't dismissed. They had said they'd heard the news but can still remain impartial. I mean, how does that work? How does Judge Cahill make that decision about what rises to the level of knowledge? And do we just take these jurors' words that they are able to remain impartial?
Unfortunately, that's kind of what lawyers are left with when it comes to voir dire. It is possible to a degree to get into somebody's mind, but that's only if they let you, right? And so lawyers and judges do their best to try to evaluate what a juror's thinking at the time. And I think on these 2 jurors that you speak of, the court felt that they exhibited knowledge but not bias. And I do think that that's possible. I think it's very difficult in a case like this. But remember, from the court's point of view, if we eliminate people who know about this settlement, I don't know that there's a lot left on the panel. So that's the kind of parsing that the court needs to engage in.
So how do we, I guess my question has been, how do we move forward? Because, this change happened, this announcement happened during jury selection. So they were able to call back some jurors, ask them about that, even eliminating 2 of those jurors. They still have a big jury pool. Yesterday we learned it's more than 300 people in their jury pool. But what happens going forward with this case if more stories like this come out?
Well, I think that's something the court will take into consideration when addressing the motion to continue or the motion to change venue. I know that the court will be weighing each of those options carefully as he considers the numbers of people who are saying, I've heard about it and there's no way now I can be fair. I mean, ultimately, the court has to feel confident that he has impaneled people who can be fair and who, in theory, can be impartial and take in the evidence that the lawyers present and submit as the evidence that they should use to decide the case, not this outside information and the outside influence of the city settlement.
Interesting. Yeah. So we're looking for people that are basically like, no matter what information I hear, I can remain impartial, whether it's that settlement or something that happens down the road.
Right. And we want people that, can have some appreciation for the legal system. And like Judge Cahill was explaining, there's civil processes and there's criminal processes. And they involve different standards of proof. They involve different parties, different lawyers, and that jurors should be able to take his direction to not concern themselves with what's happened on the civil side. So perhaps it takes a special juror, perhaps it takes a unique person, an open-minded person, maybe a more linear, logical person that will choose to not allow themselves to be swayed by emotion, but to use their intellect to take in the evidence and then make decisions about that.
How rare is this? How rare is this to have a case where you have half of your jury, just over half of your jury selected, and then something outside of the courtroom happens and you have to call those jurors back in?
I've been trying cases for 21 years and I've never seen this happen. So I think it's extraordinarily rare. But like we talked about when you and I last met on Monday, we haven't had a case like this where there's been a settlement prior to the conclusion of the criminal case. So even for those few defense attorneys that have tried cases like this and cases of this magnitude in the public eye, so to speak, there hasn't been this what I'll call interference with the civil side of things.
Mm-hmm. Yeah, and when we did speak on Monday in court, they were talking about a similar case with the former Minneapolis police officer, Muhammad Moore. Of course, the circumstances in the Noor case were very different, but they were talking about in that case, the civil suit came within 24 hours of the criminal trial wrapping up. Is that what we typically see, that those civil cases get wrapped up after or shortly after the trial?
Yes, absolutely. I did a quick look at Minnesota's cases, and I have never seen a case of this magnitude, of this type, that the civil case has been settled in advance of, and never during jury selection for the criminal case. It's very odd. And like, pardon me for interrupting, Eric Nelson pointed out, it's very perplexing and curious.
Mm-hmm. Well, everything, about this case, from cameras in the courtroom to the age of COVID, has been I mean, extremely unique, unprecedented. Like you said, you've never really seen this happen before. So how does that kind of throw a wrench in both the defense and the prosecution's strategy with jury selection when all of these unprecedented things are happening?
Well, from the prosecution's point of view, we heard them asking for a continuance on day one. When news of this settlement broke very quickly, they changed positions and, in fact, now are very opposed to a continuance. Obviously, they believe that it's an advantage for them that this information is out there. Now, they claim not to have had anything to do with the proliferation of that information, and perhaps that's true. But clearly, they see this as creating an advantage for them. The defense, on the other hand, sees this as creating a real problem for them. And in fact, they may argue that this is a bar. There's been some defense attorneys who've talked about how they would ask for a mistrial. I think that that's possible, but it appears to me that Mr. Nelson is developing the record more to support that request. He's also clearly stated he may seek that change of venue. He may seek a break, a continuance. So the defense is very concerned about that with regard to COVID and some of these other restrictions that makes this jury trial very different than the kind of trial that those of us that practice daily are used to, from masks to space to plexiglass. All of those things in and of itself concern defense attorneys about their ability to secure a fair trial for their clients because there's that personal connection missing. Attorneys like to see their jurors' faces when they're questioning them. We like to be able to get a read of their face. So it's another piece to the puzzle on what these people are thinking. The same is true for jurors with witnesses, right? And the same is true for jurors in looking at the defendant. They want to see how he reacts to information, how he interacts with his lawyer. Like, there's so many micro judgments that we're missing as a result of COVID. So I think when you add it all together, right, you had just COVID creating, a real challenge, right, a real hurdle to get over to a fair trial. Then you look at some of these other things that have happened and the irregularities in the proceedings. I mean, I think that the defense has a plethora of potential options when it comes to an appeal if there's a conviction. And quite frankly, I think the state should be worried about that. And it appears as though the court is quite concerned about that.
Yeah, you bring up an interesting point because, people have been asking me, especially after that settlement came out, why doesn't Eric Nelson just try to put a halt to this right now? But you say there could be some strategy in building the record right now, I assume, to make a stronger case for that delay or that change of venue?
Absolutely. I mean, as we, watch, the next phases of voir dire, if there are a number of jurors that just say, look, I saw that, and it seems to me that if, the city of Minneapolis feels like this was not a good case to take to trial on the civil side, well, I feel pressured, or now I believe that, in fact, I should, move to convict this defendant, then I think we've got, a much stronger case for a mistrial. Remember, it's not enough just that they know about it. It's what they make about it. It's what they feel about it. And it's about a juror's ability to set those feelings or thoughts aside. If they can't do it, and if that's, the overwhelming feeling of the panel altogether, well, then I think there's no choice for the court to grant a mistrial. And it makes sense for Mr. Nelson to develop the record in that way.
Interesting. So even these jurors that are coming in that we're hearing from that are either getting dismissed by the judge or struck by the state or the defense, you're saying even their answers and understanding who we're looking at could have an impact on how this goes forward, even if they're not selected on the jury?
Right, because it's making the record as a whole that because this settlement announcement occurred in the middle of jury selection, now it's basically poisoned the panel. And if it's poisoned the panel to such a degree where we can't impanel people who can be, in theory, fair and impartial, well, then they can't do the work. Then there is no choice but, to continue this or move this or try again down the road with some new people who perhaps over time would forget about it or would think differently about it as the information sits with them. I mean, that's the other problem about, this settlement coming out in the middle of voir dire. People really haven't had the chance to mentally process it, right? They're dealing with it emotionally, right? They're taking it in, and they probably have what I refer to as a gut reaction, right? So their heart's in it, but they haven't really had time to think about it and sort it out, understand the nuances, maybe talk to other people about it to come to a final conclusion as to what that means with regard to the criminal trial. And that's a real issue because they're in, that emotional moment. Mm-hmm. And without it being processed, then having new information, thrown at them, new information, evidence that the attorneys will present, that really puts a lot of pressure on a person trying to decide whether or not Mr. Chauvin is guilty or not guilty.
Yeah, it has been interesting this week to hear jurors come in and, they're asked specifically about the settlement. So it is interesting to hear how much information people know or how much they're retaining. You get some people who come in and say, I remember seeing something back in May, but I haven't heard much yet. And then you have other people that know a lot, almost everything that's going on. So very interesting that you mentioned it's important to watch the answers of the jurors who aren't selected. I want to ask you a question about where we're at with dismissals, with building the jury. Right now, we are back to only 7 of the 14 jurors that we need. How does that change the strategy of the defense and the prosecution using their strikes? And how does it change how willing or how flexible Judge Cahill will be in dismissing potential jurors?
So with regard to the strikes, you've seen, I believe it's Mr. Nelson ask for additional strikes. Mm-hmm. Certainly the court would be within his discretion to do that. Again, that's an irregularity in the proceedings. Typically you're given the strikes, that you're allowed, you use them, they're gone, that's it, right? Of course, for cause strikes being unlimited. So the court at this point, I don't think would roll back any strikes, certainly could choose under the circumstances with the settlement being announced to give more if he felt so inclined and thought that he was in a position to impanel a jury. With regard to strategy on both sides, I think it's pretty clear that the settlement and its announcement is going to be a huge focus of their voir dire moving forward. And I think that that is probably the point that maybe they'll even start. They want to get to the bottom of that right away, because if that has put a person in a position where, well, they have that judgment and now that is their judgment, then there's no point to doing some of that initial discussion. Let's just get to the heart of the issue and then maybe work backwards.
Sure. Interesting. One thing that I want to change gears with and talk to you about before we move forward is Judge Cahill says tomorrow he expects to rule on whether or not to allow some information, some body camera footage from an incident involving George Floyd and police in 2019 into the trial, making it admittable for trial. So my question for you is, Judge Cahill, he said no to this back in September. He even said no to this last week. There has been some new information, some FBI documents from an investigation that they're doing that kind of changed his tune. I'm wondering, what do you think we can expect tomorrow when it comes to if he'll allow this incident in?
Well, we know from the arguments and the judge's comments that he was pretty interested in this new information. And what I heard from the defense was that this new information really shed light on the fact that these 2 May incidents, approximately a year apart, were very, very similar. And what came out of it that was of particular interest to the court is that there was some indication by some treating medical professionals that Mr. Floyd was reacting very poorly to large amounts of opioids in his system. In particular, it put him at risk for a heart attack. And so the way the court was sort of attacking this issue, I thought was with a unique and creative lens. So the judge talked about what's called 404B evidence or character evidence, which is normally not admissible, but like many areas of law, there's a number of exceptions. And what the court was talking about is also reverse Spiegel evidence. So that's where a defense attorney would say, well, my client wasn't the perpetrator, somebody else did it. And here's the evidence I have that this other person committed the crime, therefore my client's not guilty. In this case, we don't clearly have a person who is thought to have knelt on George Floyd's neck. That wasn't Mr. Chauvin. Clearly, that's an established fact. But what the court was, I think, creatively referring to as reverse Spiegel or alternative perpetrator evidence was an alternative causation theory. Because there's this prior incident where we have Mr. Floyd under the influence of opioids, clearly behaving in a similar way, and having had some medical opinion provided to him about how this could negatively impact him, in fact, kill him as a result of that use, that becomes really relevant evidence to the defense's theory that it was not Mr. Chauvin's actions that caused the death of Mr. Floyd, but that it in fact was his use of these opioids. And so the court is looking at what pieces of that story could be used. And that's how we know the court was particularly interested in the potential admission of this evidence. He was talking about admitting some pieces of it and not others. And he was very careful to draw lines from relevant evidence to prejudicial or dirtying up the decedent type evidence, which he was clear that he wouldn't admit. And the law, quite frankly, says he shouldn't admit. So I think there's a good chance that Judge Cahill could introduce this evidence, and it appears as though he'll draw some very careful lines if he chooses to do that. And if lawyers step over those lines, there's some pretty negative consequences that could result. When judges issue these orders, as clear as those orders are in real practice, sometimes it can be really hard to play within those lines. So the attorneys will have to tread very lightly if he lets it in. But I think that there's some clear indications that the court believes this is highly relevant evidence, and he could issue an order letting it in.
You bring up a good point about the like muddying up, a person's character, because that's something that the prosecution came back and said, George Floyd's not on trial. Talk to us about those rules that are put in place, for victims who aren't in the courtroom. Judge Cahill made it sound like there are some very clear rules in place about what can be in and what can't be in when it comes to talking about someone's character.
Right, so the rule is character evidence isn't allowed. And then there's a number of exceptions. So typically speaking, it would be the state trying to introduce character evidence about a defendant. Here we have a defendant trying to introduce information about a decedent. So this typically would be evidence that would be disallowed, because it doesn't really matter if George Floyd was this, that, or something else, right? Unless it fits into the defense's theory or defense of the case, which in this case it actually does. So while it's character evidence in limited form, it's also very relevant evidence as it relates to the causation issue. So it's an alternative, not perpetrator, but alternative cause of death. And really that's the crux of the whole case. So this is really important evidence that the defense wants to get in. There's precedent in the character evidence rules. There's also precedent in something called the rape shield law, which a person's previous sexual history is of no relevance whatsoever in a case where there's a complaint by that person that they were sexually assaulted. However, if you can fit in information about that prior history to the rubric of some of these exceptions, it could very well come in. But it's treading very lightly and parsing those details out very carefully, because courts are very mindful about not dirtying up complaining witnesses, or in this case, a decedent.
Yeah, so to your point, if this is allowed in, lawyers are going to have to be very careful about the questions that they're asking and the way that they're using that information.
Absolutely, absolutely. And there'll be a possibility or potential for lawyers to do what we call open the door, right? So if you're not supposed to go into an area, right, and you do, then that could mean that the other side can exploit that and then bring in information that would otherwise not be admissible. So even the prosecution will have to be very careful if the judge makes this ruling in favor of the defense, because they could open things up and allow even more to come in if they're not careful.
All right. Again, we'll be waiting tomorrow morning. Judge Cahill says he'll likely have a ruling on that. My last question for you here, what are you going to be watching in these last couple of days of jury selection? We have 7 spots to fill now. We didn't seat a juror yesterday. We still haven't seated one today. What are you going to be watching through this process the next couple of days?
I'll be very interested to see where the lawyers start, right? If they start with the settlement. And I'll be very interested with how they get to the heart of how somebody's feeling, because it is easy for a person to conclude, no, I can set that aside. some relevant questions underneath that would be, well, why and how, and then relating that to other things in their life that they had to set aside, even though it was difficult to do so. So I'll be interested to see how the lawyers deal with that, when they deal with that. I certainly will be interested to see how much Judge Cahill chooses to intervene. It wouldn't surprise me, because he wants to get to the bottom of this issue, that he'll be doing more of what he did today, which is just conducting the voir dire himself. Judges can do that, and they certainly can ask questions of the jurors really at any time during voir dire, while typically speaking they'll wait till the lawyers are finished. I'll be watching to see how involved Judge Cahill gets, because it wouldn't surprise me if he stepped up and was more involved than normal.
Interesting, and it's always interesting to hear your opinion, as a lawyer who's been, in his courtroom or familiar with his courtroom, to get your perspective on that. So we appreciate it. Thank you.
Thank you so much.
Christa Groshek from Groshek Law, thank you so much for helping us through this, navigate all of this court system. We really appreciate your help.
Absolutely. Thank you. Have a great day.
Take care. Bye-bye.